ಹೇಳ್ತೀರಾ ಇಲ್ಲ ಕೇಳಿ ವಿತ್ ಮೈ ಲಾ
Kindly, my lord. One matter, my lord, I have filed. There is some small correction, my lord. Your lordship granted liberty to file writ petition, my lord. That word was missing, my lord. Therefore, I have filed application, my lord. The matter was listed before the Supreme Court, number of occasions, my lord, on the last date of hearing. Since the matter was disposed of before, your lordship and TG Simpson, my lord, directed to list that small correction. Because of that, my lord, education institution, my lord, renewal of recognition, my lord, was made earlier, my lord. The matter is very,
Petition is filed.
I'm facing a lot of difficulty.
Modification of order
Yes,
is.
my lord. The word with liberty granted, my lord, that has been.
are being spoken to.
Before other bill. Then you mention before this bench concern.
My lord, your lordship and Justice CJ Simpson, the matter was. Your lordship and.
The other bench.
Approach the registrar judicial.
My lord,
We'll do that. Not no mention. This is administratively we do that.
please, my lord, because of my lord, we are facing lot of, because middle of the education, my lord, the authorities are obstructing for running the institution, my lord. Therefore, my lord,
You move the,
Please,
will
ma'am.
take
Yes, sir.
immediate action on the
Please,
administrative.
please, ma'am.
You move the register.
please,
With your lordship kindly, serial number 41, my lord, sir.
Serial
And
number?
personal difficulty tomorrow, my lord, sir, 2:30,
Serial number?
41, my lord. Sir. This
41.
came up before the Sanwal court several times, sir. This has been heard. Your lordship directed me to produce the notification, that's all. I have produced that. I will argue the matter tomorrow, 2:30, my lord, sir.
28. 28.
28, please, my lord.
With the kindly of this court, my lords. My lords, one PIL matter. There is urgency in that, my lords. Land was acquired by the government. Subsequently, Deputy Commissioner KIDB relinquishes that land to some fictitious persons, and subsequently trial of transfers happened, my lord. My lords, petitioner had filed the matter a month ago. My lords, with if your my lords permit, kindly be taken tomorrow.
You remove the office officer, you list it.
It's removed, my lords.
Then it will list it. No need to give memo.
My lords, education matter, my lords, writ appeal preferred by KEA. My lords, candidate belonging to Karnataka local candidate who is not belonging to Karnataka local candidate has been allowed to participate in the counseling, my lords, for government seats. My lords, the counseling is going on. My lords, there's grave urgency in the matter, my lords. Your lordship may kindly take it up tomorrow, my lords. This is a writ appeal on behalf of Karnataka Examination
You
Authority.
read appeal
Writ appeal, my lords,
tomorrow.
please.
My lords, I'm the petitioner in the writ petition in that matter, my lord. My lords, the matter has been addressed at length by the single bench. Now, at this stage, if matter is stayed, my lord, the petitioner will be put to serious hardship, my lord. So
We do
correct-
not know, we have no matter. We are only posting it.
Please, my
There
lord.
is no point in arguing the matter at this stage when there is no matter available.
Please, my lord.
Why you are jumping in the,
So I have not been.
why in the jumping in the somebody else is mentioning?
My lords,
Come when the matter is taken
I'm a
up.
caveat in that matter.
We don't know any subject matter, any controversy.
Please, my lords, I shall make submissions.
Only she is making out the urgency and we are granting. Don't jump like this.
Please, my lord.
Yes, Mr.
Your Lordship, it's a matter of contempt, my lords. This Honorable Court on Wide Order 25/4/24
Yes.
had directed the Tahsildar and the IDLR to conduct Podi and Durast work with respect to a property in BM Kaval, Bangalore South Taluk. Within a span of 2 months, it's still not been conducted.
Contempt.
Yes, my lords.
So what do you want?
It's an urgency because even after a lapse of 3 months, the Podi and Durast work has not been conducted by the Tahsildar and the. That's the reason I'm.
18th September.
Monday at least, my lords, is possible.
No, nothing, no.
Contempt petition of fresh matter, contempt petition. Accuser have violated the interim order granted in the writ appeal.
Pardon?
Accuser has violated the interim order granted in the writ appeal.
Listed today.
Please,
Which serial number?
contempt petition. This is a contempt petition.
Say louder. Item number?
No, sir. Go in the memo.
Memo.
Memo, please.
For the purpose of?
Is accuser has violated the interim order granted in the writ appeal. That's why I filed the contempt petition.
Contempt petition.
Please.
For 2nd September.
This is regarding the repetition number 2405.
Yes,
My lord,
Mr.
my lord, this is regarding the PAL filed with regard to the mines funds are transferred, diverted.
With regard to
The mines funds are diverted,
mines,
mines funds,
mines front.
mines,
Fund, my lord.
fund, my
Fund.
lord.
FUND.
Let you remove the office officer. No urgency, no memo, yes. You may remove the office, you will have listed.
Contrary to the rule, my lord.
You remove the office objections and it will listed. So file आइए. File आइए. Then it will come.
My lordship.
No need to give memo, no.
Declaration suit came to be dismissed. Again, they preferred RA. That just came to be dismissed. By oppressing all these facts, they filed this petition.
19 September.
My lord's contempt case, my lord. My lords, I was working as a second division clerk in the respondent university, my lords. They made me to retire 2 months prior to my retirement date so that they could so that they could undercut the sixth pay scale commission rules, my lords, by the government of Karnataka. A writ petition was filed in 23845, my lords, and I got an order in my favor directing the respondent university to take necessary steps. But the same has been ignored for more than 6 months now, my lord. So my matter might be taken as for fresh
So
matters.
2 months have passed by.
My lords,
Your 2 months extension is gone after 6 months. What is the
my lords, the direction was issued by to consider this thing, my lords. The same was not considered, my lords.
No urgency. 19 September.
19th. My lord,
Yes.
my lords, another contempt case, my lords. I am the complainant in this case also, my lords. My lords, my predecessor in title was the owner of survey number 38, my lords. Like grantee in title, grantee of land in survey number 38, my lords. But Saguvali chit was not issued, my lord. Subsequently, a writ petition came to be filed in WP number 9976 of 2020. And the Honorable Court directed the issuance of Saguvali chit, but the same has not been complied with, my lords.
No urgency. No memo, yes.
After the dismissal of the respondent number 124 are interfering and doing the construction of the land.
Which matter? Your file. What is the urgency? What is the urgency?
Respondents are interfering and respondent number 124 of the.
File it and remove the office of the.
My lordship.
Serial number 50.
Yes,
I'm party in person.
yes.
It's pending for reinstatement.
Pardon?
I'm out of employment and it is pending since 1.5 years. Writ appeal is filed. And when I gave the order of the honorable court, they did not even receive my order from the high court. And I have filed a contempt. Both are connected today. The serial number is 51.
Today may
Kindly
not,
accommodate my lordship.
today may not be possible because the court may not be available after
My
recess.
lord, say last time your
So we'll
honorable
take-
self gave me 22nd, today's date.
True, but today the court may not be available in the second half. So today it may not be possible.
Morning, if you could.
So we'll post it on 2nd of September. 2nd September. On that day you mentioned,
Please, my lord.
give that matter.
My lord, serial number 57, writ appeal number 969 has been listed today. A connected writ appeal is listed or scheduled on 9th September, my lord. So it may be posted then. Today there is some
57.
difficulty. 57, writ appeal
That-
number 969.
Learned advocate Miss so and so. What is your name?
Manasa,
Manyata.
Manasa,
Manasa
yes.
stated that this writ appeal is required to be listed with writ appeal number
Along with writ appeal 972
972
of 2024,
or 24.
24,
Full stop.
Oh.
Both may be listed together on
9th September.
9 September.
Your lordship,
As
a
requested.
mention with regard to serial number 53, your lordship.
Pardon?
Serial number 53, W8 330 of 2024. There's an urgency in this matter, your lordship, if the matter can be taken up during the course of the day. The reason is, this is an order erasing, this is a writ appeal erasing out of a single bench order with regard to section 5A of Land Acquisition Act. We are questioning
Land acquisition.
land acquisition, your lordship. What the acquired land has been developed, your lordship. It's in the process of developing. I'd be put to serious injustice if the development takes place and an equity is claimed. I have the relevant photographs to show that the development is taking place, your lordship.
So any other day than today,
If a date can be fixed, I'll be grateful.
2nd September.
Grateful.
My lords, list number 1, serial number 34. I appear for respondent number 10.
Serial number?
34, my lords. I
Yes.
pray for 3 weeks' time. Senior is traveling because there is a bereavement in his family. Senior is traveling because there's a death in his family. I humbly request that the matter be listed after 3 weeks. A date may be fixed.
After
3 weeks, my lords.
3 weeks.
I'm for the petition.
As requested. It was requested that the present appeal may be listed after 3 weeks. any of the request and over to 30th September.
Grateful.
And permission. Contempt matters, seal number 1,
Appeal for
party GS.
two number 2, my lord. We have completed the direction, my lord, filed a complaint.
What is returnable on
Correct. We are completed the direction, my lord.
29th September?
They have complaint endorsement as.
Yeah, we should endorsement, we are completed them. I have filed a
Complied
complaint.
with.
Yes,
Complied with
yes, my lord.
both the learned advocate state. You are for
Complainant, my lord.
learned advocate means, what is your name? So and so
Kala
states
Deepa
that
Yola.
the order under contempt is complied with.
With liberty to challenge the
When
endorsement.
just
matter
appearing for the
proceedings may
respondent
be dropped.
confirms the statement of compliance, in that view, nothing survives in the present proceedings, the contempt petition is disposed of as not survived. Yes.
Seal number 2,
Lords,
Kumar BL.
serial number 40, my lords, today writ appeal is also filed, my lords. Same matter, my lords. There are certain directions there, lordship may kindly tag along with this.
To be listed with
One submission, my lords.
writ appeal
But-
number. Serial number 20.
40, my lords, 40,
40.
40.
Since in respect of the order brought under the contempt jurisdiction, writ appeal number 742 of 24 is referred by the university. Both may be listed together on 3rd September.
My lord, in the writ appeal, there was a direction given by my lords. My lord, I'll make my submission. My lord may post it on the 3rd.
Which one?
My lord, writ appeal, which is at serial number 40.
Both are listed on that.
Yes, my lord had directed the university to place the, this thing, my lord, proposal before the government. My lord, the department has also, my lord, examined the proposal and now it is placed before the finance department, my lord. So if some time could be granted, then I'll be able to apprise my lord of what has
Little
happened.
longer.
Regularization of 128.
You want a
years.
longer date?
My lord?
You want longer date
No, my lord. my
on
lord.
that?
One submission, my lords. Let's, in this, my lord, I am for the respondents, or they are all D group employees, my lord. And their services have been regularized and their service have been withdrawn. And without giving an opportunity, their service have been withdrawn and they are without salary and without employment.
So therefore, they are taking some steps.
As a short date may be given because this cannot be clubbed with those other matters, so 128.
It can't be shorter than 3rd September.
Because they are all without salary and lots. At least direction may be given to the, at least university to at least.
That day will come.
Obliged.
Obliged.
The date has been fixed, Milad. Date
3rd September.
3rd September.
3rd September. Public.
Other one matter, writ appeal is kindly connected, Minister. Other university will file another writ appeal, Minister. 711/2024, Minister. Along with, kindly connect the along with, Minister.
Which university?
Today is not listed, Minister. Same,
Then why you are mentioning?
Minister.
If today it is not there, what is the point in mentioning?
Minister, same writ appeal, same university filed a.
Which university? We do not know which university.
Sorry, Agriculture University, Minister. Agriculture University.
There are many universities. We don't know any matter. You point out specifically what do you want? What is the subject matter? Not in this fashion. Don't waste time. What do you want? Which matter? What is the subject matter? What is the urgency?
Serial number 40.
Now you tell us 40. So what do you want? What do you want? About 40 is already urgent to 3rd of September.
No. I'm appellant, Minister. Serial number 40, I'm appellant, Minister. I filed 3 writ appeal, Minister. 2 appeal is listed today.
Which is the other one?
742 and.
That is already done, Mister.
And another one writ appeal is pending, Minister. 711.
Where it is there. Once it comes on board, we'll pass the order, not without.
Seal number 3. To Mahesh, yes.
What is returnable on 29th September? Still number 4,
Appear for a
Ramesh
complainant in
KR.
this matter, my lord. My lord, non-compliance of order passed by single judges of this honorable court, my lord. My lord,
notice written on 28 September,
apply.
not 28, 27 September. Both 27 September. Number 5,
A paper
Mahesh?
complaint, my lord. In this non-compliance of the order.
Same.
My lord, short date may be given, it says, the university, the institution, nursing institute, admissions are going on. With regard to the affiliation, they've cancelled, discontinued the affiliation. This institution is running from 4 years. Now citing some reason for non-production of 2 documents, it was rejected. Later, we have produced, the single bench order was to consider refresh before 8th of August. But before 8th of August. But they have not considered our application.
Notice.
My lord, short date maybe because they are not taking very seriously.
Earlier you want, early,
Yes. And someone's.
11 September. 11 September. So PL matters, still number 6.
Lord, sir, for the petition, this
File
case.
filed in number 6.
I apologize.
Reply is filed here. In number
No,
6.
my lord, my lord, notice is not issued. It was dismissed for
Okay, I will
on
give the note.
28th March
I'll serve a copy.
2024.
Notice is not issued.
No, my lord.
Not, my lord, before filing the case itself, you have to serve a copy in the government and do yourself.
Copy.
So I will give a copy, there's no problem, my lord. I'll give a copy if that is required.
Pardon?
No, she's saying that she don't have any copy as such. At the time of filing itself,
No, you argue what is the matter.
oh, please,
for the
please.
first time.
Lord, the petitioner is a public spirited person and not, he do not have any personal interest in this, in the interest of general public only, my lord, is preferred the present petition, lords. The petitioner preferred, my lord, earlier, WP number 9115/2022. The said petition was withdrawn to file a fresh petition for the reason not state government was not made as a party to the proceedings. That particular judgment, I mean, order passed by the Honorable Court is produced as Annex AJ, page 281, my lord. Let us come to this page 281, my lord. Page 283, my lords. Page 283, the learned counsel for the petition submits that the petition is exposing the public cause in the right petition. He submits that due to some wrong notion, the petition directly approaches the Minister of Environment, Forest and Climate Change, Government of India, by way of application dated 21/1/2021. Instead of approaching the office of the officers of the state government, he further submits that the petition intends to approach the approach and approach the office of the state government. Therefore, on premise, the place for withdrawal of the writ petition, which are liberty to file a fresh petition after taking all the necessary steps. My lord, based on this, my lord, late, my lord, I filed this this petition was filed, and I'll make this chairman Karnataka State Pollution Board as a party to the proceedings, as also the director of Industries and Commerce, as the chairman of Karnataka Pollution Board Control Board. I mean, 2 parties they made as a party. They are the state organizations, my lord. I've made them as a party. Now, my lord,
Notice returnable on
much obliged.
Your lordship, I take,
27 September.
your lordship, in this matter, I take notice for the Karnataka State Pollution Control Board responding.
Terminated of it, Miss Vaishnav.
Yes, your lordship.
What's your
For-
name?
Krishika Vaishnav,
Krishna Vaishnav.
Krishika Vaishnav,
Kritika.
Krishika.
Kritika Vaishnav waives
I'll serve a copy.
accepts notice on behalf of
Please, I'll serve.
Respondent Pollution Board and learned advocate, learned additional
the government
learned
also.
advocate, Miss Nilofer Akbar.
Please, I'll serve.
Those posted.
I'll serve.
Number 7. Somsekhar H.
But I'm giving the lordship. The synopsis, my lord, I'm giving not to. Lordship, currently, my lord,
First matter, my lord, should take my the annexure N for a moment. This is the order passed by the government. Blood on 29/9, blood. This is an order by the government on 29/9/2022 to collect 599 crores 53 lakhs 31,544 and an amount of about 216 crores 37 lakhs 28,677 from fourth transplanted club. This is the order passed by the government based on the cabinet decision. Your lordship come to the facts of the case. This is the order passed by the government based on the cabinet decision. But till today, the government has not taken any decision or BBMP has not
Land
taken.
was given to BBMT by whom? BBMT
By the
was-
fourth respondent club, fourth respondent club,
Originally, land was given to BBMP for some,
to the fourth respondent club.
not.
Yes, my lord. Your lordship, I'll come to the facts, my lord.
The land was given to BBMP for some public utility. It was given by whom?
Given by the BBMP to the, my lord, the fourth respondent club.
We are asking that originally the land was given to BBMP by which party? By private party, by
No,
government?
no, it's a government property. It's a government property.
So
It
there-
is controlled by the BBMP. It's a my lord playground in the CDP, my lord.
TS survey number, CTS number 1378, which was given to BBMP.
Yes, my lord.
Given by whom?
Given with government only. Government.
Where is that?
Lord, lordship, kindly see, my lord. Land bearing survey, land measuring, my lord, 4 acres, 28 guntas.
Where is that?
It's a corporation property.
So something that it was given to BBMP for the purpose of this public utility and children's playground.
Lord, lordship, kindly see, my lord. The petitioner was a 1 minute, I'll explain, madam. Petitioner was a
Get the
corporation.
answer, we will not proceed further.
But there is a lease,
We want
granted,
an answer, otherwise we will not proceed further. You show some document whereby your averment is fortified that the land was given to BBMP for the purpose of public utility and playground.
but it has been reserved as a playground in
Where is that?
CDP.
Where is that
In C-
source?
That is throughout the proceedings, dishonorable court, direct dishonorable court, blood, held in India 90.
Then you produce some document.
Lordship, kindly 1994 order, blood, dishonorable court allowed my writ petition and said, blood, it's a property belongs to the BBMP and lease given by the BBMP is wrong. Lordship, kindly, blood,
Where is
annex A, page number 25, blood.
Page 25.
25. I filed a PL in the year 1994 itself. When I was corporate ex-MLA, I filed this writ petition along with others, challenging lease granted by the BBMP in favor of the fourth respondent. The dishonorable court not allowed my writ petition, set aside the grant made in favor of the and cancel the plan also. From 1994 till today, I am fighting to keep this land as a playground.
That is all right, but originally it was given for playground. Where is that?
I will show this in the CDP blood. It is there in the CDP. I'll produce the CDP map plan. CDP. In the CDP, this land shows as a playground.
Where is that?
Your lordship, kindly in the annexure A, there is a finding by the dishonorable court.
Let us see if there is a finding or a statement in the judgment or anywhere in the order at page 159 you show.
No, I'll produce the document.
It is not there.
No, it is there, man. It is there. It is playground only. It is a famous cricket club, cricket ground.
Then show us.
Played by Mladi Vishwanath
Then
and other cricket players have played that in the ground. Illegally occupied by the fourth respondent Jamkhana ground. They are using entire 4 acre 28 guntas for their club purpose. They have not given for the sports activities. No children has gone to this one playground. They are occupied illegally. Therefore, 59 crores has been ordered by the government itself. And 219 crores, totally 719 crores they have to pay. This is ordered by the government.
query is not answered.
What?
Our query is not answered.
I produced the copy of the next week.
When will learn and advocate seek for this for the petition 6 time? 10 to 25th September.
Thing for the,
Sumoto writ petition PIL.
Is that contempt PIA?
yes, the affidavits have been filed by the
Any of you have prepared something, some suggestions?
Manoj, in fact, what I've done is, Manoj, there are totally around 41, 42 departments, Manoj, in the government. I've just bifurcated number of contempts in each of the department, Manoj. How many complied, not complied, what is the time required for compliance by each of the departments, department wise, Manoj. And what is the system in place so that any contempt, once a judgment is passed, and some of them writ appeals have been filed, Manoj, so therefore the contempt may not survive some. So I'll give the list of all those 41 departments, which are the contempt list. I need under any reasonable time your lordships feel, Manoj. I'll come with all the data statistics and the system that I'm going to.
You furnish detail, we want to
streamline the whole.
set down some guidelines and then.
And if my learned friend has any
Put an end to
suggestions
the-
or anything, Manoj, they can place, we'll adopt that, Manoj.
there is one particular, there is
10,
one.
11th,
Please, Manoj, that should be
11th or 12th September.
any day. In the meantime, Manoj, any suggestions from the petitioner side also?
Yes, my lord, I will share that suggestion also with them, my lord. I will also file before this honorable court. My lord, there is one particular provision, my lord, which empowers the government to issue the direction also under the act, my lord, which has been referred to in the affidavit filed by the government of Karnataka. If those suggestions are taken into consideration and my lords consider it, when they can issue a direction to that effect with respect of various
Consider
departments.
this.
Yes.
Yes, sir.
No,
12th
my only one thing, Manoj, sometimes what happens is the writ petition is filed, direction is given, contempt is filed. Only in some of these cases where there are cases where it has to be appealed, Manoj. The contempt court should not be a executing court for an order which has to be appealed, Manoj. That's the only, keeping that in mind, Manoj.
That also will take care.
Take care, only that, Manoj, because sometimes what happens, Manoj, not to say too much, Manoj, there is, see that fate accompanies is that.
Only thing is, in many cases, you file appeals after long time of the order.
No, again,
And
those,
during dependency of.
I'm sure, in
So
fact,
that-
Manoj,
that
that's
will
the
be
most
streamlined.
important, your lordship. I bow down to your lordship. A mechanism has to be placed and person should be held responsible to file within the limitation.
That will-
That also I'm taking care. I look into that also, Manoj. No,
My lord, only one submission, my
important
lord.
thing,
If
Manoj.
my
I'll
lords,
look into that.
if my lords permits one submission, my lord. There is one affidavit has been filed by the BBMP, my lord. And BBMP has adopted one particular case monitoring system with respect of the disposed of cases also, so as to monitor it. And they have adopted that particular ecosystem, my lord, that has been explained by the officer of the BBMP, my lord. And that is a very good idea, my lord. What I personally feel that, my lord, if that particular system, that ecosystem is adopted, and that particular, the moment an order is passed, my lord, it will pop up on the computer of that particular section officer. And that particular order, my lord, he has to comply with that. And then, my lord, an intimation will be sent to the office of the Advocate General. That has been explained.
Prepared something.
No, I have not prepared. That is the affidavit which has been prepared. That
What-
affidavit has been filed, my lord. And that particular officer who has filed this affidavit, he is the person who adopted, who introduced the system of Bhumi in Karnataka. That is also Dishant.
I'll clarify to my friend, it is not the BBMP, my lords. There's a High Court website, my lords. There's something called CCMS.
Yes.
Case Monitoring Management System of the AG's office connected to all the 41 departments. All these cases, each department have got the list, my lords. It is connected to the AG's office, their department and the High Court. So today the matters are listed, my lords. For example, this order is passed. It comes to our office and directly goes to the department. And in fact, they can watch the proceedings to show what cases they have particular day, what order is passed. That is not of the BB government for all the departments, including BDA, BBMP, my lords. So therefore, that is where I was coming to, my lords. I'll fix this thing in order. Let him give it suggestion. I'm not arguing. Let him give it. We'll take into account and we'll do it, my lords.
At 2:30, 12.
Please,
Yes, ma'am.
please.
Yes.
Before that,
It-
I'll, 2 days before or something, I'll get it filed. Let me.
I will, in advance, I will serve my suggestion also, my lord. I will file before this honorable.
This is number 9, the Shyam Kumar issue.
This is although today there is some time constraint, therefore today will not take up this, but this we want to hear at length, this prison aspect.
They have not filed the reply yet, my lord.
My lord, in this, I pray for some time. My lord, I'd like to justify, my lord, the amendment that has been made, which are all pursuant to the directions of this honorable court. My lord, along with the writ petition, my lord, other incidental problems have also arisen. My lord, some time may be granted, my lord, 4 weeks' time.
4 weeks.
My lord, it's not only parole, it is with regard to, they are averring with regard to, my lord, the public police torture. My lord, it doesn't take place in a prison. At least 3 weeks' time, my lord.
My lord, may I make a submission, my lord?
The present is a public interest petition.
May I make a short submission, my lord? The incidence of large-scale torture was reported in 2022, and denial of parole due to pending appeal is going on since 2020. Therefore, they are all languishing in jail and many of them suffering. Because of this urgency, your lordship may put those provisions in abeyance in the meantime.
No.
They are all in jail because no parole given because of the pendency of appeal. It's a sheer arbitrary action proposed by those amendments. Those amendments have to be kept in abeyance. And parole in whatever reasonable cases must be given, my lord. Otherwise, they are all languishing in jail.
My lord, once
Very easy. It is very easy to say I take time, 4 weeks.
No,
Even
no,
last
no,
time
no,
also
no.
they took 4 weeks time. But every time, my lord, the incumbents are in jail. They must consider that also. Put those provisions in abeyance so that it may not continue. This torture instance in rampant reported since 2022 and still continuing. Now petition is for reply.
My lord, once, my lord, a convict is sent on parole, goes on parole. My lord, we have found incidents where they don't come back. My lord, the address that is given, my lord, once when the my lord, investigation takes place, my lord, it is found that the address that is given is incorrect, and we are not able to, my lord, arrest the convict who has gone on parole. We have all those issues which I have to bring it to the notice of my lord.
Yes, those
Parole
instances,
given by this honorable court has been abused.
my lord,
That is not being put forth before my lord.
those instances are 1 or 2, but this is a report pertaining to 51 jails, my lord. It cannot be because of 1 or 2 instances where it has been jumped. The parties who have jumped the parole cannot give excuse for them to continue them in jail in 51 jails, my lord. This report is given in 2022.
It is not that we are adverse to allowing them to go on parole.
The petitioner is the High Court Legal Services Committee, which has instituted this public interest petition, advancing the following prayers. Prayers are at page 25, A to F. You make it small Roman 1 to small Roman 6. Undoubtedly, the subject matter raised is one of importance and involves the rights of the prisoners to seek temporary release, parole, or remission which in turn flows from fundamental right to liberty, which has the wrapping of the fundamental right of liberty under Article 21 of the Constitution. Notice was issued paragraph in the petition as back as on 26th June 24. Full stop. The petition still awaits filing of a reply by the respondents. Paragraph, when the petition comes up for consideration today, from a learned additional advocate, Srimati Nilofer Akbar, additional government advocate, Nilofer Akbar, read for further time to file reply, stating that 4 weeks time will be granted. To stop looking to the subject matter of the public interest petition. How much? The reply needs to be filed at the earliest, therefore, no time could be granted to the respondents to file reply, except up to 10th of September.
My lord, that's too short. My lord, I'd like to look and do some research and then bring forth to my lord. My lord, the problems that the government is facing, the prison authorities, the police, then I leave it to my lord. But 10th is too short, my lord.
September to be listed for hearing at 2:30 on 19th September.
Obliged.
Much obliged.
The rate appeal matters, seal number 10. Don't have the same.
Writ was filed to enforce power. Writ petition was filed by the generator my lord, to enforce clause for extension of time of the power purchase agreement. My lord. In fact, writ is not maintainable in view of section 86(1)(f) of the Electricity Act. My lord. If any dispute between the generator and the distributor, my lord,
Go to the Regulatory Commission.
please, absolutely.
Or learned Advocate General. You are in capacity of Advocate General or Senior?
As senior counsel, your lord.
Senior Advocate, that's Shashikaran Sethi, assisted by learned Advocate Ms. So and so for the appellant. So then what about merits?
On merits, my lords, I would concede, my lords, insofar as it is only the KERC which can extend the time. The appellant cannot extend the time because clause clearly says that my power to extend is only for 6 months. That is what we have communicated, saying that my power is to communicate only for a period of 6 months. They had to adjudicate. In principle, my lords, if it's extended, it's a power project, it's in the interest of the state, my lords, and they've almost implemented. What is heartening here is, my lords, court has found fault with the appellant and imposed a cost of 5 lakhs. My lords. In fact, the respondent has failed to implement the project.
It's section of which?
86(1)(f), my lords.
While assailing the impugned judgment and order dated 30th August 2023, asked in the writ petition, from a learned senior advocate, inter alia submitted that the exercise of jurisdiction by a learned single judge, it submitted that it could be that the learned single judge could be said to have exceeded his jurisdiction inasmuch as the dispute in the writ petition was
81, 1F,
liable to
adjudication,
be tried statutorily
please,
under section 86(1)
F, my lord, F,
F.
F, my lords. 86, 1F, adjudication upon the dispute between.
Three, first of the state section provides that that the state commission shall discharge the functions including, as per clause small f, to adjudicate upon the disputes between the licensees and generating companies and to refer any dispute for arbitration. It was therefore submitted that when the statutory jurisdiction was vested in the commission under the act, learned single judge was not justified in entertaining the petition and issuing the directions. Notice returnable on 24th September. The directions of learned single judge issued in the impugned judgment and order shall remain in abeyance.
Can I make one request, my lord? The whole judgment need not be issued, only in so far as the observation, because they are implementing.
Has
the-
two paragraphs.
Please, my lords. Paragraph number, my lords,
22 and 23.
please, my lord, that should be, can I request 21 and 23, my lords?
Directions in paragraph 21 and 23 shall remain in abeyance.
Please, that should be sure. In fact, they've almost implemented the project and
Till the next date.
till the next date. One delay is there, my lords. 47 days delay is there.
Delay is there. Then notice.
Then your lordship may fix a date, my lords.
Notice returnable on 11th September.
If can I take, notice in addition to serving the council who had appeared before the single, in addition, my lord.
It will be permissible to show a copy of the appeal to the learned counsel who appeared in the writ proceedings, in addition to
In-
serving by normal mode of service.
Please, grateful.
Number 11.
Sir,
Appeal by the state.
in this matter, my lords, I'm told that on the last state of hearing, the earlier order of the learned single judge at page number 100 related to, my lords, three petitioners at page number 100, my lords. And the state had implemented, my lords, in respect of two petitioners, but had contested the matter in respect of one petitioner. The state had, it was brought to the notice of the court that in respect of petitioners number
Your
one,
appellant.
Please, I appeal for this one.
that in
This was heard earlier.
It was heard, and it was brought to the notice of the court that in the order dated 9th of July 2008, there were three petitioners, and a direction was issued by this honorable court for reconsideration. But in respect of two petitioners, my lords, it was implemented, but in respect of the original petitioner, the respondent herein, it was not implemented and the state had taken it to appeal. Then, my lords, we had realized that in respect of petition number 1 and 2 there, it referred to Kalburgi division. So by oversight, my lords, it got implemented. Now we have taken steps, my lords, to withdraw that because it was by error. And on law, my lords, they are not entitled to. That documents are in Kannada, my lords. We want to place it on record with the translation. Can it be taken up, my lords, 2 days time, my lords? We will place it on record because the learned single judge has allowed the writ petition only on the ground that the other two petitioners, my lords, were given benefit. But now, my lords, we have realized why it was implemented. We have taken steps, and it was found by oversight that referred to Kalburgi division, and Davangere comes under Bangalore division. So therefore,
You have withdrawn the benefit.
we have withdrawn it. And we'll place it on record because the order is in Kannada. Translations are yet to, we are getting it done today, my lords. Maybe in 2 days time, we'll place it on.
That withdrawal is not challenged,
No, my lords, not yet,
not yet.
not yet. We have passed it. my lords.
May I make one submission?
That will have a bearing on this case because the single judge is allowed only on that ground.
My main objection in the matter is this writ appeal, which is filed before my lords, is under the wrong impression that the petitioner has challenged the constitutional validity of the Karnataka private aided educational institution employees, which has been set aside by the, my lord, writ in the writ petition. Entire writ appeal, reading from para number 3 to last prayer para, it is pertaining to some other writ petitions, which is not at all the present, my lord, order of the learned single. That is what I brought a notice of the last occasion. Your lordship may kindly see para number 3 in the writ appeal. This order of the learned single is not challenged in this writ appeal at all. Altogether different writ petitions under the impression.
Para number?
Kindly come to para 3 minutes. In the all the above said writ petition.
It is about the grant of some benefit.
No, what happened is, my lord, the petitioner who was appointed, my lord, as accountant in the year 1989, he is, my lord, I'll give it 27/5/1989. The petitioner was appointed a first division assistant cum accountant in a private educational institution. My lord, his appointment was approved by the, my lord, competent authority on 28/12/1989. My lord, sir, at that relevant point of time, the government has, my lord, imposed a ban on admitting the appointment of the private aided employees. That is called economy major, my lord. That no private employee of the private education institute is not entitled for any grant. My lord, on 9/6/1999, my lord, the government took a policy decision to admit the grant to 1,116 unaided employees. It is a government policy decision made, my lord. My lord, under this government policy decision lifting the ban of economy, my lord, the petitioner's case was considered for admitting grant. My lord, what happened is there is a mistake in considering the case of the petitioner by a delay of 5 years by the government. Government, my lord, the commissioner on 22/11/2004 admitted the grant of the petitioner appointment, and he was salary should be commenced from 22/11/2004. 3 petitioners, my lord, have approached this court in the year 2008, stating that their case should be considered and grant order should be passed from 9/6/1999 because the government itself said that a grant should be given from the date of 9/6/1999. When this honorable court in their 2008 passed an order, within a year, 2 petitioners, number 1 and 2 in that writ petition, have been extended benefit in their 2009, my lords. It is almost 15 years back. Then, my lord, I preferred appeal before the government. Government allowed my appeal under section 130 of the Education Act. When the appeal was allowed, government has directed commissioner to only request is that the grant should be extended with effect from 9/6/1999. That is the only, my lord, grievance which has been extended by the government. The commissioner immediately filed a review petition in the said government appeal, and the review petition was allowed. I filed a writ petition before this honorable court. This honorable court allowed writ petition. By this time, the petitioner has retired in the year 2020. The claim of the petitioner is only this. His appointment was admitted to grant in aid on 22/11/2004, which was given effect to from 9/6/1999, only 5 years previous, because with the date of with the effect from the date of government order. That is the subject matter.
You were appointed.
SD, my lord, appointed as first division assistant, come, my lord, accountant in the Millat Educational and Welfare Society, Davangere, in the SKH Composite Pre-University College.
In 2004.
No, my lord, 1989, my lord.
18.
And appointment was admitted to approval without grant on 28/12/1989. From 1989, he was serving without any salary, without any grant for a period of 10 years. Government took a policy decision. My lord, entire state Karnataka, whoever.
You got the salary or not?
22/11/2004. Order has passed by the commissioner admitting my appointment to salary grant.
Between 89 and 1999 did not?
No, not done. Therefore, that has been challenged before this court. This court quashed the endorsement stating, directing the authorities, you have committed a mistake in not considering the case of the petitioners. Lord, out of 1,116, only 3 employees have been left out from consideration from 9/6/1999. When we have brought a notice of this court agreed that yes, it is a mistake of the authorities due to inadvertence of the authorities, your case not considered. Therefore, their case should be considered with effect from 9/6/1999, and salary should be given with effect from government order date 9/6/19. Within 1 year, 2009, in respect of 3 petitioners who approached this court, 2 petitioners in the year 2009, benefits have been granted by the government itself. From 2009 till today, my lord, by this time also they have retired. Now, my lord, only petition has been not been granted extension, and he has been denied the benefits. That has been allowed by the, in the, my lord, in the appeal filed before the Education Authority. And this honorable court also, my lord, directed that you are bound. It is not only, my lord, what the government is submitting, that other two petitions have been given, my lord, benefits. Therefore, their order should be recalled. Then automatically I am also deprived. That is not the case here. I will show from the government order. Government order may kindly be perused from 9/6/1999 itself clearly says that the benefit should be given from the date of this order. The said posts are eligible for receiving grant only from the date of issuance of this order. 9/6 page 85 you may kindly be seen. I am eligibly, my lord, I am legally entitled for the, my lord, benefit. Not, I am not claiming file a writ petition on the ground of parity. For the moment, may kindly be perused, my lord, the order which the government, my lord, passed on page 85, clause number 2, my lords. Page 85. One second.
What is it? Page 85.
Before that, just peruse 83. What is the substance of the order?
83.
83. Writ appeal. 83, Lordship gone. The government order dated 9/6/99. The government has given the approval for providing of the grant in aid under the stopping properties of the private aided high school and private aided university college for those non-teaching staff who are appointed prior to 1/1/1990. And during the time of earlier government order dated 24/3/1996, there were 323 non-teaching staff, and these staffs were included while providing the grant in aid. Therefore, as the economy austerity was in force, during the time of appointment of these non-teaching staff, along with the other 490 non-teaching staff, in total 1,116, the same has been relaxed and government has been given permission for providing a grant in aid. Then your lordship may kindly come to page 85. Conditions. Your lordship got it. Condition number 1, grant in aid staffing pattern appointment must be made accordance with the rules prior to 1/1/1992 and must have been approved by the concerned appropriate authority, and at this time age and qualification, education qualification employee must be confirmed. I confirm the eligibility. Second condition, said posts are eligible for receiving grant only from the date of issuance of this order only. Lord, we are eligible for grant with effect from 9/6/1999. Now, your lordship, what happened is the authorities have not considered the case of the petitioners. My lord, page 95, my lords. Our case has been considered, and my lord, our appointment has been admitted to grant in aid. Page 95. My lord, on 22/11/2004, order has been passed by the respondent, appellant commissioner. Therefore, as explained therein, the proposal permission has been granted to these 90 non-teaching staffs for granting of the grant in aid under certain following conditions therein. Condition number 2, the said posts are eligible for receiving the grant only from the date of issuance of this order. That the grant has been given effect to with the date of this order, that is 22/11/2004. Your lordship, name of the petitioner is appearing in page number 98, whose appointment has been. Lord, in page number 98, the person's name appearing serial number 7, 8, and 9 have filed a writ petition. Petitioner respond number appearing is name appearing in serial number 9. Then, my lords, we filed a writ petition. Lord, this honorable court has held that it is due to the, my lord, inadvertence of the authorities that the name of the petition has not been considered. Therefore, we are eligible for grant in aid with effect from 9/6/1999. The order passed by this honorable court, page number 105, my lords. Para number 5. This honorable court, my lord, observe that it is due to inadvertence of the authorities that the case of the petitioner not considered on 9/6/1999. This is the subject matter, man. My only grievance is Lord, my only grievance is the grant which has been given from 22/11/2004 would have been given with effect from 9/6/1999. That is the only, my lord, grievance. In the entire state, my lord, all the 1,116 employees have been given benefit to with effect from 9/6/1999, except the petitioner alone, my lords. Except the respondent alone, my lords. I am the only person who have deprived of this. All others have been, my lord, granted benefit. Now, your lordship, now. May I?
The order of the finance department is on the record.
My lord, this, my submission before this, kindly see para number 3 of writ appeal. And government under the impression that the petitioner has responded, challenge the constitutionality of the Karnataka Private Education Institution Employees Act 2004 and pertains to some other matter, my lord, writ appeal is filed. My writ petition is not at all challenged in this writ appeal at all, my lord. Kindly see from all the paras in the writ appeal.
Which page?
From para number 3 of the writ appeal. That's what I'm submitting before this court, and the last occasion also, this honorable court raised a query to the government. They said we'll clarify. Para number 3 of the writ appeal may kindly be perused. Respondent writ petition order is not questioned before this court at all. It pertains to some other matter. Para number 3 of the writ appeal, I will. May I read, madam? Para number 3. In all the aforesaid writ petition, the petitioner has asserted the constitutionality of the act called Karnataka Private Education Institution Employees 2004. The said act was enacted by state government with a view to regulate salary allowance and other conditions of service of teaching and non-teaching employees, staff of private education institute on their admitting to grant in aid and limiting the financial liability, state and matters connected there incident therewith. The Karnataka Education Act 1980, though enacted in the year 1983, and so on and so on and so on. This writ appeal pertains to some other matter, not in this writ appeal. Petitioner, respondent's order was not challenged either, my lord, under the facts of the writ appeal or the grounds therein. Only in the prayer column, my lord, my order has been questioned. Entire body in the writ petition from page number 1 to page number, my lord, 32. It is pertinent to some other matters. My matter is altogether
Explain the-
different.
May
They
I
have to, Lord,
I just explain the context.
Number?
from page number, my lord, 1 of the writ appeal to page number 32 of the writ appeal, entire, my lord, the pleadings and averments in the writ appeal pertains to some other matter. In this case, my lord, writ appeal before my lords, my order by the learned single judge is not at all questioned. No grounds, no averments in the petition, nothing.
Lords, I'll
They are under the impression that they are.
explain the context. Lords, there is the institution, my lords, wherein the petitioner was working. That is the respondent number 1 herein, original petitioner, is an aided pre-university college, my lords. In an aided pre-university college, he gets appointed, my lords, on a particular date. Then thereafter, my lords, sometimes if it is with the approval, my lords, of the government, from the date of the appointment, my lords, the salary grant is there. And in some cases, my lords, it is from a subsequent date. In an aided institution, my lords, there will be two kind of posts. One post which are admitted to salary grants, other posts which are not admitted to salary grants. When the private institution appoints a person,
In page number 15 of the writ appeal, your lordship may kindly see what is under the impression the writ appeal is filed.
no, I will explain the context, my lords.
No, only two sentences I mean. Plain reading of above rules clearly demonstrate that the persons working in private aided university colleges are eligible for grant only from date of sanction of the grant in aid by the government, and unaided service shall not be counted for any fixation, increment, leave, seniority and other service benefits including pension and initial pay of the such. So they are under the impression, my lord, that during the non-grant period from 1989, I am seeking for seniority, pay and pension, and my lord, leave and increment and fixation and other benefits I am seeking in the writ appeal. That is not the case at all.
Notes. In a private pre-university aided college, there will be two kinds of posts.
At least streamline your pleadings.
Please.
Because the entire discussion or the pleadings are in respect of challenge to the validity of some.
Yes, Lords, what had happened was, the date of his salary grant is 2004. He is claiming, my lords, from the date, a previous date to the date of his admission to salary grant. My lords, we had bought it that 2014 Act, my lords, whereby, my lords, we had made it a statutory rule to state that only from the date of admission to salary grant, all benefits will accrue. It is not before that. Before that, the private educational institution will be paying the salary. In fact, he has taken the salary from 2004. He has retired. Pension also is being paid to him. Now it is only about computation of 5 years period. Now, my lords, I have stated also that that act, my lords, was struck down by this honorable court, a single judge of this honorable court, my lords. Thereafter, my lords, writ appeals are pending. In the writ appeal, there is an interim order of stay. And whatever payments were being continued to made, we are making it, my lords. And the writ appeal court also has said that further contempt proceedings should not be prospected because multiple contempt proceedings are there. Now, my lords, in the context, I have given in paragraph number, kindly see, my lords, the pleadings at page number 20, my lords, for a moment. I have pleaded, my lords, large-scale ramifications. In page number 20, below the tabulated statement, I have stated if non-grant period is reckoned for the purpose of payment of salary and other service benefits, there will be huge financial burden of 4,775 crores on the state exchequer, approximately to the tune of 351 crores for every year. So that issue, my lords, is still at large. Here, my lords, single judge has given benefit only on ground of parity that I have given benefit to the two other persons, and I have withdrawn it. That is what I'm making. I'll place it on record, is what I'm saying. And my lords, if any further additional statement has to be filed with regard to clarification on facts, I will just place it on record.
Throughout the proceedings from 2008, government has, my lord, continuously misleading the authorities. My lord, I am not claiming, my lord, arrears with effect from appointment from 1989. It is not the case of the petitioner at all. My lord, the government took a policy decision in their 9/6/1999 to admit the unaided employees. It is not that I am claiming any arrears, anything from date of appointment, my lord. It is a special, my lord, scheme formulated by the government on 9/6/1999. By virtue of that special scheme formulated by the government, it is a policy decision to admit unaided employees. I am not seeking anything, my lord, without any basis. It is the government which, my lord, facilitated me to take the grant.
That's, and all the orders are passed.
The government itself, my lord, takes a policy decision on 9/6/1999. Government can, my lord, the government cannot now say, no, you are not entitled in spite of the government order dated 9/6/1999, you are not entitled for.
Let's kindly
Then this 9/6/1999 order itself, my lord, according to them, it is a nullity in the IF.
Where is that 9/6?
Please, my lord, page number.
You showed it.
80, my lords.
Oh, page 80.
80, my lords.
Lords, if my lords may see one order of the earlier in WP number 3521 of 2006.
Then be fair.
Lords, what kind? Lords, the
Page 80, my
Even
lords.
in the impugned order of the learned single judge, it's presumed, my lords, that in the earlier proceedings, his entitlement from 99, my lords, is already decided. Kindly see, my lords, page 100. I'll just point out one paragraph operative portion, my lords. Page 100, my lords, is the order dated 9th of July 2008, page 100. I'll just read the operative portion and show what exactly the learned single judge asked us to look into. My lords have page 100, my lords. Then operative portion, my lords, at page 105, if my lords may kindly see. Para 5 onwards, my lords. In the light of the facts and circumstances of the case as stated above, the writ petition filed by the petitioners is allowed in part. The impugned communication dated 10th October 2005 issued by the first respondent bearing so and so, wide annexure is hereby set aside. Matter stands submitted back to the jurisdictional competent authority of the respondents for reconsideration of the request of the petitioners and to take appropriate decision in accordance with law after affording reasonable opportunity to the petitioners and after collecting necessary details from the institutions where the petitioners are working and dispose of the same as expeditiously as possible at any rate within a period of 4 months from the date of a receipt of the copy of this order. Further, the petitioners herein are permitted to submit their detailed consolidated representations along with necessary notifications, orders and other materials to substantiate their claim that they are entitled for the said benefit from 9/6/1999 and not from 21/11/2004 within a period of 4 weeks from the date of the receipt of the order of this copy. Now, my lords, court has said it has to be looked into. Kindly see what the learned single judge had said by this order. Lords, may I just make one submission?
Page number, no, in the same order, kindly see para 4.
Lords, may I just make one submission? Lords, the fact that we have withdrawn the benefit that was given in the single judge's order, it was only on account of the fact that benefit was given to 2 other persons.
How will you improve your case by producing those letters?
No, my lords, I'm not only.
Otherwise, there is nothing.
No, my lords, not only that, because it was only on that ground. In the earlier case, court had said, consider whether they're eligible from 99 to 2004.
Para number 4 may kindly.
But the commissioner, my lords, presumes that that court has directed that 99 to 2004 has to be considered. There is no adjudication. Therefore, in the revision petition, it is set aside. And the issue whether they're entitled from 99 to 2004 has not been considered at all. It could be considered in this appeal also. I'm saying, but since in view of the fact, my lords, that on the last date of hearing, the fact it was brought to the notice of the court and it was also recorded in the order of the learned single judge that I had already granted benefit to the 2 other petitioners at page number 100. We have taken steps, my lords, to find out how it was granted and also withdrawn. That is another aspect of the matter. His entitlement may be considered. I'll just place it on record and it may be considered is what I'm saying. Whether he's entitled from 99 to 2004, there is no adjudication either by the learned single judge. It is only because somebody was granted by mistake, he's claiming parity. 99 to 2004, let it be considered. He's being paid pension now. He's getting benefit of that. My lords, he is superannuated. Till the date of superannuation from 2004, he has been paid the salary grant.
You are considering notionally.
Notional, my lords, notional and refixation, that is all it is. Therefore, matters are still at large. I may be permitted because any order passed here I have stated in the writ appeal, my lords, it has large scale ramifications for the state because there are other similarly situated persons. That is the only concern.
Produce the withdrawal tomorrow.
Please, day after, my lords, maybe Monday. Monday.
Only one submission. Lord, your lordship, my learned friend led the para number 5, page 105. Before that, para number 4 may kindly be produced. This honorable court clearly observed that petitioner entitled from grant with effect from 9/6/1999. There is an observation, my lord. It has not been read, my lord. Para number 4 of the page 104, lords. Para number 4 of the writ petition. Para 4. After careful perusal of the materials available on record, what it emerges is that in fact, government has approved the grant in respect of 1,116 non-teaching staff appointed between 1190 to 1992, and appointment of these petitions were also fall within the said period. Therefore, authority ought to have called for the report from school colleges where these petitions working, but inadvertently or by oversight, their names have not been included for extending the benefit of the government order dated 9/6/1999 for fault of them, and when approval has been accorded by the government, it ought to have called for details from the persons who have not been extended benefit, and contrary, as per representation dated 16/8/2005, first respondent has issued impugned communication dated 10/10/2005 stating that these petitions are entitled for grant from 22/11/2004 and not from 9/6/1999 without any justification or without any assigning any reasons, nor there is any reference regarding the thorough verification of the particular of these petitions as to whether they are entitled for extending the said benefit, and unilaterally first respondent has taken decision and issue the impugned communication stating that they are not entitled for a grant without assigning any reasons. Therefore, impugned order communication issued by the first respondent 10/10/2005 annexure A cannot be sustained. On merits, my lord, this honorable court already, my lord, observed that we are entitled for grant with effect from 9/6/1999. Now, my lord, not on the basis of the parity I am claiming. On the eligibility, I fully, my lord, fulfill the conditions in the government order dated 9/6/1999. Therefore, I am entitled from grant from 9/6/1999. Leave apart, my lord, whether other persons have been extended benefits by the government or they are not. On the merits, my lord, on the basis of this very government order, which is dated 9/6/1999, I am claiming the benefits.
Notes para
No,
4.
this cannot they deny because government having formulated the scheme
We
cannot
understand.
now deny.
Notes. Let him have the satisfaction.
Please.
27th at 2:30.
Please, members. Pardon?
On 27th at 2:30.
Grateful.
2:30.
27th October. September. August, sorry.
Whichever you want
No,
September.
no, my lord. Sorry. Please. Much. Grateful. 11.1 contempt is connected.
It is there along with.
Please, next matter.
To be listed on same day.
Please, much.
Still number 12.
Your Lordship, I appear
Mike.
for I appear for the caveat respondent in this case, Your Lordship. I seek for a short accommodation.
My humble request, my lord.
Absolutely.
This is the petition, my lord. The trial court, instead of reinstate into service, award has been passed directing the respondent to pay 6 lakhs rupees, my lord.
Still number 12.
Yes.
Lord, I appear for the caveat respondent in this case, my Lordship.
Petitioner is not there.
Your lordship, kindly maybe
Seek for a short accommodation.
interim direction, my lordship. Payment has been withheld
You are
since
for
from
whom?
April, my lord.
You are for whom? You are for whom, Mr. Kam?
I appear for petitioner, appellant, my lord.
No. What is it about?
17B, my lord, applicable during pendency of the proceeding, my lord, which is continuously paid by them during writ petition. Now, after passing the order, withheld since from 4 months, I am not getting any salary because they are very much aware that the writ appeal has been filed. Para number 7, my lord, of the order, my lord, without any inquiry, I was terminated. The labor court I was directed to reinstate, which was admitted by them.
Why you are here for wage wages?
My humble request, my lord, after reinstatement order has been passed, there is a scuffle between the manager and himself. Some word he has used against the manager, for which the suit has been filed for claiming damages that came to be decreed. That is questioned in RFA, my lord. Another criminal petition has been filed against me, my lord, after only reinstatement order passed by the labor court. That observation has been considered and awarded only 6 lakhs rupees, my lord.
Come better come physically. 12th September.
Number 13.
Please.
Before the appellant. Sir, are you in the G right?
Yes.
Lord's case of compassionate appointment, my lords. Lord's appellant herein is the mother of deceased government servant who was working as assistant professor, who expired on 6th of May 2022, my lords, who was the son of appellant herein.
But the relief is granted to you by requiring.
My lords,
consideration.
relief is granted to daughter-in-law. I am the mother. My lords, my daughter-in-law sought direction from the court. I filed an impleading application.
So who are you?
Lords, I am mother, my lords. I am not seeking for compassionate appointment.
Then
I am seeking for, my lords, relief in the matter of Calcutta High Court Coordinate Bench's judgment wherein, my lords, because daughter-in-law has moved away from the family in crisis and she is not maintaining the family in crisis, she is very much the eligible condition under Rule 4 Clause 1. Because she has moved away, I am seeking, my lords, let there be a subsistence allowance or medical allowance to me. My lords, even the learned single judge, my lords, if my lords, 3 of the impugned order says I have considers I have applied for compassionate appointment. My case is not that I am eligible for compassionate appointment. My case is that because she has moved out from family, because there is no one to look after, my lords, will find the findings at page 29, para 3, my lords.
your party before learner single judge.
I had filed the impleading application. My impleading application came to be rejected considering that I am applying,
In the
seeking.
post title of the order, you are not reflected.
My lords, I have filed impleading application, which came to be rejected at para 3, my lords.
Granted.
I have filed for IF for permission in writ appeal also.
It was granted by the single judge.
My lords, he rejected on the ground at para 3, my lords, of impugned order. He rejected on the ground that I am seeking compassionate appointment and I am not eligible. So I am not a necessary party, but that was not my case. daughter-in-law filed, my lords, seeking for a mandamus for compassionate appointment, directing the respondent number 2. Meanwhile, I filed an impleading application. And my lords, learned single judge was of the opinion that I am not eligible because I am 65 years old. My case is that I am not asking for compassionate appointment and I'm only asking for subsistence allowance. Because she has moved out from the family and my son was, I was dependent on my son at the time of his death. That aspect is not considered by learner single judge. On that note, I am before my lords. SR, SHR, Sridhar. Lords, if I may.
You are not seeking compensation.
No, my lords. My lords, what happened is.
Nor you are objecting to the appointment given to your.
To certain extent that, my lord, she has moved out from the family in crisis.
What is your grievance to this?
My lord, because she has moved out from the family in crisis, there is no one to maintain me. Because at the time of death, I was dependent of my son. I was dependent on him. As per rule 4, one of the rules, my lords, 1996 rules, she should be in family in crisis.
If you are seeking now.
My lords.
What relief you are seeking?
That there be a subsistence allowance, my lords. Let her from her salary. That is, my lords, as decided by the coordinate bench also, my lords. Lords, I will rely on the decision of coordinate bench, my lords, which my lords may allow me to circulate. I am seeking a similar relief in that manner, my lords. Because there is no one to maintain me now.
Maintain?
Lords, there is no one to maintain me, my lords.
Then it is nothing to do with this compensatory ground.
Lords, rule 4.1 says that because if she want to, my lords, if she is eligible, compassionate appointment rules. I have 2 copies. Sir, excellent. Lords, rule 4.1, if she has to apply for a compassionate appointment, I have extracted at page 9 of my memo also, my lords. Rule 4.1 says, it speaks about conditions of appointment under compassionate ground, my lords. So if she is intending to seek for such an appointment, the first is that, my lords, family of the deceased government should be in financial crisis or destitution. Lord, the explanation that to that effect is, family of a deceased government servant shall be considered to be in financial crisis or destitution if the recurring monthly income of the family from all sources is less than the total emoluments, including DNS allowance and so on. Admissible at Bangalore on the average at the minimum and the maximum of the scale of pay of the post of first division assistant as on the date of making application for compassionate appointment. Lords, my respectful submission.
What you are reading?
Lords, rule 4, my lords. Rule 4, which is the eligible, which is very condition for appointment on compassionate ground. So I'm challenging her compassionate ground appointment on the ground that she is not in family in crisis. Even memo of petition, she herself claims that, my lord, she has moved out of the family in crisis. My lords, in the background, my lords, if I have to say, when she had applied for compassionate appointment, my lords, the department, the respondent number 2 institution had sought for a consent letter from the appellant herein. So also a family tree, including appellant's name herein. My lords, both of them were not given. On that count, my lords, she claimed that mother-in-law is not part of my family, and consent letter, so also family tree, including mother-in-law's name, is not required. And she also sought a direction from this court by filing the writ petition, my lords. And under this background, my lords, the impugned order came to be passed. My respectful submission is that, my lord, she is not residing with the family in distress. Such being the circumstances, my lords, she is not entitled when she is not ready to maintain the family in crisis. Very 4(1) is not complied with. On that sole ground, my lords, I am before my lords. Admittedly, my lords, mother is the class 1 legal heir of son. And she was residing, that is also admitted fact. I filed a suit seeking share in the emoluments. In there, my lords, she files a return statement seeking half share. So is in nowhere, my lords.
Sorry, there is nothing. Dismissed.
Please.
Number 14, Rahul is ready.
Yes.
I beg to appear on behalf of it.
The land bearing survey number 74. This is for an extent of 1 acre 38 hectares belongs to respondent number 3 and 5. Then in the year 2007, that is on 24/11/2007, he executed the agreement of sale in favor of this petitioner by receiving 95,75,000. Then thereafter, your lordship can see when he failed to execute the sale deed, he filed a suit for specific performance and omitted a decree. Thereafter, he filed an execution petition, and during the execution petition, my lord, the court has executed the sale deed dated 12/12/2022. But by suppressing this fact, my lord, during the year 2009, the respondent number 3 borrowed a loan of rupees 1,05,00,000 lakhs from the first respondent bank. Then thereafter, your lordship, the bank has initiated the proceedings and put into action. Wherein your lordship can see this respondent number 6 has purchased the property in action. Thereafter, your lordship can see they went to the sub-registrar office for getting the sale certificate registered. At that time, sub-registrar has given an endorsement stating that no, they already civil court executed the sale deed and refused to register the sale certificate. He approached this court, lordship in the single judge directed to the sub-registrar to execute the sale deed in respect of this sale certificate. Wherein your lordship will say, I am not a party, because of that reason your lordship is seeking permission. This court has granted the permission and I filed this writ appeal. There are so many properties as given a collateral security, including this property. That was not put into action. Only this property has put into action.
Now this is leave to appeal. Was granted. So before that, the writ appeal was numbered. How can it? Unless leave to appeal is granted, how appeal can be numbered? This is one of the instances where leave to appeal application was granted by the court by order dated 7/8/24. However, it is noticed that before the leave to appeal was granted and the order granting such leave was passed, the writ appeal of the proposed appellant was already registered, full stop. If such is the rule operating, it needs to be amended. The registrar judicial shall put up the issue on administrative side before, on administrative side. Next. We'll see after 2 weeks. Put up on. Issue needs to be examined on administrative side. Therefore, registrar judicial may be put up, may put up the subject matter on administrative. Send over to 13th of September. 13th. 13th is a holiday? No, 13th September. How can your appeal registered before the grant of leave to appeal?
The seeking permission, your lordship is allowed in my application.
Then only the appeal can be registered, not before that.
No, no, lordship, again, what happened? I am not a party before this court. Try, single
See
judge.
on 13th, we'll see.
Still number 15. Mr. Watson.
I'm for the appellant.
Yes. What is this serial?
My lord had heard this matter with regard to the revenue entries.
Case.
On 7/8/2024, the arguments were concluded and it's posted today for orders.
Which is that? That Nagunda.
Yes.
That they dismissed. Appeal by whom?
Appellant.
Dismissed.
So,
Fine.
Still number 16.
Respondent
Appeal by
states
state.
appeal. The subject matter of appeal is survey number 2 of Pinia village, measuring about 65 acres. Lord, there is a delay of 713 days in filing the writ appeal. Lord, may I just seek your lordship's indulgence? Because the expression sufficient cause, my lord, is also approached with justice-oriented approach because of the public interest involved to the large extent because of 65 acres. And this 65 acres survey number 1 and 2, my lord, I'm instructed and I have also learnt with interaction that the forest department has also claimed interest in this land because of the notification declaring this land to be a state forest way back in 1896, my lord. So your lordships are also have considered judicial institution as a stakeholder when it comes to the forest land. And the forest department has also recently recovered 18 acres of land in survey number 1, my lord. We are now concerned with survey number 2. Your lordship just gives me 2 minutes to explain the facts, my lord. Now, this is a proceedings arising out of 136(3) of the Karnataka Land Revenue Act, where this special deputy commissioner, my lord, examined the mutation entries of the respondents 1 to 5, my lord. The respondents 1 to 5, my lord, claimed right by virtue of a re-grant order passed under the Inams Abolition Personal and Miscellaneous. My lord, may I just
But there is a delay of.
my lord, delay of 713, my lord. Now I have explained in my, they have not filed objections to my.
We are not notified, my lord, my learned friend.
No notice has
In the
been-
writ appeal,
no notice has
we were
been
not
issued.
notified.
My lord,
Will by state. First, we have to see these 617 days.
Lord, I'll just-
Not small delay.
Not small delay, my lord. But may I just briefly explain 2 minutes of facts, my lord? Now, my lord, the respondents 1 and 5, my lord, as petitioners, challenged the order passed by the deputy commissioner with regard to the mutation entries, my lord. The respondent's mutation entry was MR2 of 21 of 65 and 66. They are claiming right by virtue of an order of regrant by a special deputy commissioner under the Inams Abolition Act on 24th of May, 1965, my lord. Now, the deputy commissioner, after giving notice, they have participated in the proceedings. It is categorical finding of the special deputy commissioner that it is not a Inam village at all. Jodi Inam, Pina village is not a Inam village at all. My lord, the Inams Abolition Act has a schedule which notifies all the villages where the act is applicable. So the question of them claiming that the special deputy commissioner had granted this land to them under the Inams Abolition Act does not arise at all. Your lordship will kindly see, my lord. This is the categorical finding at page 289 of the special deputy commissioner in the order that was challenged in the writ petition.
Now there is an appeal pending, order in writ petition was they passed. 3207 of 2009. So today, the entry in your name.
No, they had deleted my name, therefore the learned single judge has restored. Therefore, I had filed the contempt. In fact, the writ appeal is filed long after filing the contempt.
Where is the restoration?
Please, my lord, in the contempt petition, your lordship may
No,
kindly
no,
see page
the
20.
direction to restore is there.
Page 22. In the contempt petition, page 22, or the last paragraph, paragraph 13 of single judge's order.
As a consequence,
Revenue entries as they stood prior to the impugned order passed by the special deputy commissioner. My lord, it was this. My lord, the Lord, this is the mutation entry.
136. Karnataka land revenue.
And revenue. And revenue. Your lordship is going through Karnataka Land Revenue Act, my lord.
So the authority is while acting under section 136(3).
136(3).
Exercise powers under the different act.
They cannot go into anything other than what is the right acquired. And they want a mutation entry of 1965-66 to be cancelled now after about 45 or 50 years. And in the civil suit, they have lost. Inam abolition order, they have not filed the appeal, they have not filed the revision. It has become final.
My lord, may I make a submission?
And none of those things will be of any subject matter in a proceeding under section 133 to 136 of the Land Revenue Act. Learned Judge has pointed out that specifically para 5 of the Learned Single Judge's order, my lord. It has to be stated here that power conferred on the Deputy Commissioner under section 136(3) of the Act is to verify whether the entries have been made in revenue records are valid and have been made in accordance with the prescribed rules. The Deputy Commissioner would thus have no jurisdiction to come to conclusion that the order on the basis of which mutation was made was itself incorrect. The Deputy Commissioner could have at least held that entries were illegal only if the entries were made without any legal basis. Admittedly, in the instant case, Special Deputy Commissioner has affirmed that there was an order of Special Deputy Commissioner under Inam's Abolition Act on 24/565. Pursuant to the said order, a mutation has been done. It is also not in dispute that the revenue entries right from 6566 reflect the name of the recipient of the order of Special Deputy Commissioner for Inam abolition and not the persons who acquired title thereof from him. It is therefore clear that Deputy Commissioner had no jurisdiction to come to conclusion that the order of Special Deputy Commissioner under the Inam's abolition dated 24/565 was incorrect while considering the regularity or irregularity.
Dismissed. The,
Lord, may I just one submission.
there is
Just
nothing,
one
absolutely,
submission.
absolutely.
Just one submission. Now, my lord, there is a categorical finding by the Deputy Commissioner.
The authority acting under one act cannot
Yes.
decide the issue
Yes.
pertaining to other act.
Yes, my lord.
That is a very well settled.
Yes, my lord. To that extent, my lord, to that extent, my lord, may I just
The
make one sub?
Inam issue could not have been gone into in 136(3) proceedings.
Yes.
And could not have been decided.
Yes, my lord.
Not only that, that is final because there is no challenge. Number two, there is only a civil suit pending. And the entries are which are of fiscal nature and revenue nature, we abide by the outcome of the civil suit. That is the three things in the matter.
Please.
One other submission, one other submission. Now, the special DC, the invalidity of their order when they approach this honorable court in a writ petition. We have said that the order of the special DC cannot be, the Inam, it's not a Inam village at all for the order to be passed by the special DC. Is also by way of a defense that we have taken in the statement of objections. They were required to show not their own arguments, which is recorded in para 4,
But
says
not in
the
the-
legal basis.
It can't be gone into 136(3) proceedings. That's the whole.
But in a collateral proceedings, which is in a writ, when they approach this honorable court, my lord, when we have taken up that defense in the statement of objection. Or may I also request, my lord, that the state also may be given liberty to pursue in accordance with law, because fraud has been committed when it's not an Inam village at all, my lord. When it's not at all a Inam village, I can understand, my lord.
Nobody prevents you to take out a.
All right.
But we are not going to observe in the appellate process.
Please.
First, with your lordship permission, Lords, I have filed IA number 4 of 2024 for implement. Lords, I have filed the document which shows that the entire extent, not only the 65, there is a larger interest up to around 599 acres, which was notified as forest land. In fact, this matter is also seized by Supreme Court, where the state has filed an application for deforestation, for denotification. So we have also filed a writ petition which is pending, which includes this survey number. If your lordship may kindly note my IA number 4 of 2024.
Nothing to do with this. Yeah, next.
Please.
Or so at least liberty may be given, my lords. Let this.
But no liberty in the appeal. We are in
Lords,
appeal,
may-
not in 226.
I
We are in
understand, Lords.
appeal.
My lords,
No
my
miscellaneous, no miscellaneous observations.
My lords, my writ petition, which also includes this survey number, writ petition number 1505 of 2020, connected with writ petition 9496 of 2021, and writ petition number 17737 of 2024, It is still pending before your lordship. My lords, this order, at least let it not come in my way, my lords.
We are
In
observing
deciding that,
nothing. We'll deal with each matter on its own merits.
my lords, an observation that this order of your lordship will not come in my way will at least suffice, my lords.
Nothing, yes. Contempt will be, as far as contempt is concerned, the order shall be completed within 6 weeks.
Please. 6 weeks.
Number 17. Rajendra Kumar Shinde. 17.
Till number 70. Do some date long.
Sorry, my lord. Number 17, my lord, just here.
What is it? To heard earlier?
Yeah, contempt.
Lord,
Read appeal.
Granted single judge, my lord, second order, Lord, has directed the university, my lord, to issue a degree certificate, which, my lord, which is challenged, my lord, in this case, because, my lord, the student has studied in the study center, my lord, and there was a direction, my lord, issued by UGC. If there is no territorial jurisdiction study center, my lord, you are not supposed to issue a certificate. In this case, my lord, what has happened was, though, my lord, student has studied, my lord, in the year 2008, has completed in 2008, a provisional certificate, my lord, has been issued. My lord, the degree certificate, my lord, was applied after the lapse of 15 years, now, my lord, in 2022. The MSc IT, my lord, the course is considered as a technical course, for which, my lord, the recognition of the AICT, my lord, was required. Because the university, my lord, had a MOUs with academic collaborative institutions, even inside and outside the state of Karnataka. In fact, UGC had discontinued its recognition for the university from 2012 to 2000.
Why you did not issue the degree certificate, convocation certificate?
My lord, 2008, my lord, she has passed out. My lord, 2022, my lord, she has applied, but
your duty to issue the certificate. Where is the question of application?
No, my lord, for degree certificate, my lord, notification would be issued by the universities, my lord, every year. Whoever, my lord, wants, my lord, they would file an application along with all the documents, all the mask cards of the copies of the mask card, which would be verified. And after it's found that she has passed and all the documents issued by the University of Chennai, then, my lord, it will be, a list will be prepared, that would be sent to the Honorable Chancellor also, my lord, who would approve that. Thereafter, only, my lord, in the convocation, my lord, it will be issued.
Why you did not issue the degree certificate? You answer that. Some technical restraint. What was the technical restraint? What was the technical restraint for not issuing the degree certificate at the relevant time?
Relevant time, my lord, it's in 2022 she has applied, my lord.
He passed out when student?
2008, my lord.
Then why did you not issue?
No, for a certificate, issue of certificate, my lord, when the notification was issued, they have to apply. If she would have, I think, my lord, if she would have applied in 2008 or 9, my lord, the university would have issued. But now, because this was a technical course, my lord, what happened? Up to 2012, my lord, there was a recognition by the erstwhile Distance Education Council. That was called, my lord, institution recognition. Whatever the courses university do, my lord, that we used to be recognized. After 2000, UGC, my lord, is coming to force. After UGC has come into picture, my lord, they said the university had to take the recognition in the subject wise, not the institutional wise.
This MSc IT, my lord, we are not offering MSc IT in the university, my lord. It was the academic collaborative institution which would enter MOU with the university, would conduct this examination, my lord, and this course and the issues, my lord. Because my statement of objections, my lord, I have filed at page number 47, my lord, is the objections filed by the university before the learned single judge. There was a direction by the UGC, my lord, at page 51, the communication 18th of August 2021. The last paragraph, my lord, in page 53, it says, therefore, the Karnataka State Open University directed not to issue any degrees for the years for which either university is not recognized or the territorial jurisdiction which has not been complied. If any violation is noticed, punitive action shall be initiated against the university. Because of this reason, my lord, the certificate was not issued.
Which was the course? MSc.
MSc IT, my lord, information technology. Through distance education, my lord, the university is not supposed to have these technical courses, my lord, which requires the approval by AICTE, my lord. That was the main thing.
Hard learned advocate, Mr. So-and-so, the appellant university. The university seeks to challenge order dated 20th June 24, passed by Lawrence Single Judge, whereby while disposing of the petition, statement made by the government councils for the respondent UGC was recorded that the convocation certificate will be issued to the petitioner at the next convocation. Full stop. At the same time, it was directed to the university. That's original is number 1. That's appellant hearing to issue the degree certificate to the petitioner within 8 weeks. The facts of the case available on record show that the petitioner passed out the Master of Science in Information Technology into bracket MSc into bracket IT, bracket over MSc bracket, then MSc, then again small bracket IT, bracket over. In the year 2007-2008, through the distance education from Dharwad Study Center, which was affiliated to this number 1 Karnataka State Open University.
It's not affiliation, right? It's called
the copy of the mark sheet was issued by the university to the petitioner, as well as issued was the provisional degree certificate awarding B grade. It was the specific case of the petitioner that she studied the classes, passed the written examination and obtained the degree.
The recognition was granted to the Ispan University by the Distant Education Council in August 2007. It appears paragraph that the petitioner was not issued the degree certificate, notwithstanding, comma, for her post-graduation degree. She made an application for issuance of convocation and degree certificate by paying necessary fees on 20th to 24th. It is further stated that in the meantime, the petitioner successfully held a PRED for the post of assistant professor from Department of Master of Computer Applications, VTU's post of PS, VTU's PG Center, Muddenahalli, and appointed on the post with effect from 29/1/2014. Even after completing, the petitioner was not issued the convocation certificate and the degree certificate. Therefore, the petition was filed. Paragraph 11, a single judge observed that the distance learning center from which the petitioner obtained the degree after undergoing the studies was within the territorial jurisdiction of the university. It was not the case where the distance education center was outside the territorial limits of the operating university. The center was at Dharwad, attached to Ispan 1, Karnataka State Open University. It was also a finding recorded by a single judge that not only the study center was within the territorial jurisdiction, it was recognized by the competent authority, and that the aspect of its recognition was not disputed. No valid ground could be pinpointed by the university to justify the stand of not issuing the degree certificate for a long time. The conduct of the university in depriving the petitioner of degree certificate and to put her to serious difficulties deserves to be deprecated. Full stop. When learned single judge has recorded the statement made on behalf of UGC about the issuance of the convocation certificate in the next convocation, and has further directed the university to issue the degree certificate within stipulated time, no error could be booked from any standpoint in the order and the directions of law and a single judge. The challenge thereto is meritless. The appeal is dismissed.
We are for the appellants, so not the not the challenge is to, my lords, the dismissal of my writ petition.
7470 was filed by whom?
Not
Father-in-law.
by, my lords, my husband, 7470. The appellant's husband, my lords.
Father-in-law.
No, the husband, my lords.
Husband.
Husband. The appellant's husband.
Against?
That is the, against, my lords, the order of the, this thing, against, my lords, the respondents, that is the the father, and, my lords, the appellant's father-in-law. My lords, this is a dispute, my lords, under the Domestic Violence Act, and, my lords, the
challenge is 753. So the 7539 was
7539 is filed by me, my lords.
against?
Against, my lords, page 24, my lords. So 7539, my lords would find it in page 29, my lords. In page 29, my lords, WP 7539, 1, 2, and 3, my lords, are the appellants before my lords. The respondents are, my lords, the Assistant Commissioner, Bangalore North Subdivision. Respondent number 2, my lords, is my father-in-law. Respondent number 3 is my husband. Respondent 4, my lords, is Tashildar.
You are also there? What do you say?
The impact of this dispute on the mind of such a young mind, it can be resolved. It's not
There's no
difficult.
dispute between the husband and the wife. Finding, in fact, is that the wife has played fraud on the court by approaching this court. Para 31 minutes.
Wife has played fraud.
Fraud. Because it's a frivolous case. The domestic violence case is a frivolous case, is what the finding is. My lord may see at page 60 of the.
You are for?
I'm for the father-in-law.
Lord, everything can be forgotten, my lord, and started afresh.
there's one other aspect I have to bring to the notice of the court. What happened is that I had filed 482. My 482 was dismissed saying that you file a 226. Against that, my lords, I have approached the Supreme Court against the same order. The idea was there's a judgment of this honorable court that against a dismissal of a 482, my lords, a writ petition, a writ appeal is not maintainable. Diary number, my lords, I'll just pass it. Already approached the Supreme Court. Pass the judgment also.
But I have not challenged, my lords, the dismissal of, my lords, the 482s. In fact, if my lords were to look at my prayer at, my lords, page 21 of, my lords, this appeal, I'm, my lords, only concerned with, my lords, the writ petition that I had filed and, my lords, the dismissal. In fact, my prayer.
You are right.
I'm the wife, my lords.
So it's a common order, my lords. Findings are common in both.
Page number 21, my lord.
Common order. All four matters have been heard together in a common order. It is not possible to sever it. My lords, the difficulty that all of us face is it's not possible to sever the order and challenge only one portion of the finding before the division bench of the High Court. And for the other portion, I must be relegated to the Supreme Court. It's not, both parties will have to necessarily go to the Supreme Court by virtue of judgment of this honor.
That's in fact, the judgment, my lords, the learned single judge separates, my lords, the two sets of challenges, my lords, before the learned single judge. In fact, the two writ petitions, my lords, are taken and my lords order is, there is, my lords, one set of findings. And my lords, separately, from my lords, page 62 onwards, my lords, the learned single judge has categorically, my lords, gone into the question of, my lords, maintainability of the 482s. In fact, my lords, page 62, if I could request my lords to look at, of my lords, the appeal memo.
So what is the writ not maintained?
It is not maintainable, my lords, because of the fact that it's a common order which is passed in respect of 482 as well as this. And all findings, my lord, are interlinked. It is not possible to delink the findings. Although my learned friend would point out that insofar as maintainability of the 482 is concerned, there are separate findings. Thereafter, my lords, were to see, there's analysis of the DV Act and the Senior Citizens Act. And on that basis, my lords, The ultimate order, my lords, is that
This appeal is in respect of order passed in one of the petition only. That is 7539.
Please, my lords. 753.
My lords, I just wanted to point it. That's it. So I will not come in the way. My lords want to entertain it, my lords, I cannot come in the way.
The act of 7539 can be segregated
Please.
and for the purpose of dealing with the appeal.
But the only difficulty, my lords, the only difficulty is that the problem is that, my lords, insofar as against the same order or whatever the findings, my lord, I have.
It is not the common order in the manner you are trying to submit.
Yes. In fact,
Yes,
the
I-
judgment, my lords, that is cited by my learned friend. There, my lords, writ petitions and my lords 482s came to be filed, my lords, in respect of a complaint itself. In fact, that is, my lords, not the case here. In fact, there are, my lords, separate orders, separate proceedings that are, my lords, challenged here. The writ petitions seek to challenge, my lords, the order under the Senior Citizens Act. The 482s that were filed, my lords, by my learned friend seek to challenge, my lords, the domestic violence proceedings that, my lords, were pending. Therefore, my lords, again, the very nature of the proceedings also, my lords, are entirely different.
The difficulty, my lords, is that in the senior citizens case, he's saying that because the domestic violence proceedings are pending, the entire case in the writ petition is that because the DV Act proceedings are pending, therefore Senior Citizen Act proceedings cannot prevail.
There are no merits.
I'll address, no difficulty.
Please.
I'll address them.
It's not
Lord,
the-
if it could be sorted out, my lord, after all, it is between, my lord, the
I mean, my lord,
parents, the
My lords-
mother and the daughters,
My lords-
daughter-in-law.
Just one. My lords, what?
It is entirely right.
My lords, in fact, my lords, efforts were made. What has happened is that, my lords, the son and the father, my lords, son abused and manhandled the father. Father filed a police complaint. Son filed a counterblast suit in Bijapur, my lords, and making the father traveling up and down there. Then father had no other, because father was not being given access to his basic amenities, he had to file a petition under Senior Citizens Act. All of those aspects, my lord, the learned judge has not gone into, because learned judge felt, let me not get into all of those aspects, because ultimately we are on the merits. Because if we get into that, they also have my lords, their contention is that father is depriving me of the property. My lords, in fact, offer was made that we'll make a will. Till we live, till we die, we'll stay in that house. That is the only property that he has, self-acquired property.
You want to go for mediation?
My lords, we tried, my lords, it's failed. My lord, it's failed. Lot of efforts were made, my lords.
My lord, bygones are bygones, my lord.
My lords, it's not.
My
My
lords,
lord,
were to
he's a cancer patient, my lords.
We kept
He's-
apart, but, my lord, small two girls are involved.
My lords, he has another house, my lord. It's just an ego battle. He has another house. He is fully paid for an apartment. He is not executing a sale deed. My lords, he's earning 80 lakhs per annum.
You tried for mediation at which place?
please.
At what, sorry, my lord?
At district level.
My lords, in the writ petition, my lords, matter was referred.
In the writ petition.
My lords, His Lordship Justice Krishna Dikshit, my lord, summoned both the parties, my lords, for four days, 4 dates, my lord. He counseled everybody, my lords. Lot of efforts were made, my lords. My lords, the ground floor, my lords, I am staying, my lords. First floor, my lords, he's staying.
Second floor.
Second
I'm staying in the second floor. The first floor is rented by.
I'm sorry, my lords. Son, my lord, son is staying, son.
Second floor is daughter-in-law.
Daughter-in-law and son. My daughter-in-law and son.
And you are husband.
I'm the father-in-law, my lords.
You are the
father-in-law of the appellant.
And where is the son?
My lords, son and them are together, my lords. In fact, they were represented by the same council. Son also files the same writ petition saying that domestic violence proceedings must be stayed because the senior citizen proceedings must be quashed because he has filed a suit for partition. Son is claiming the property to be a joint family property and he's filed a suit in Bijapur. They're represented by the same council. That is the finding, my lords. If I can just read page 60, my lords, it says that
Writ appeal number 1186 of 24 heard learned counsel for the respective parties and considered the subject matter. Essentially, and in the background of the litigation leading to the filing of the present writ appeal, there exists a family dispute in which the future stakes of the minor children are also involved. Be as it may, paragraph. In the facts of the case, appeal shall be listed for final hearing on 26th September, 25th September. By of interim leave, it is directed that the parties shall maintain status quo.
My
with
lords, may
regard
hear
to
me
the
on
subject matter house. And further that neither of the parties shall transfer, alienate or encumber in any manner whatsoever the subject matter property.
So I have only one subject to
In
what-
addition to the above order, since the dispute is family dispute and the court sees in the dispute an element of settlement, the subject matter dispute is referred to the High Court Mediation Center. The parties shall appear, the director of the mediation, High Court Mediation Center shall assign the mediation to a senior advocate and intimate the parties about the date on which they are supposed to appear. Full stop. The outcome of the mediation shall be placed on record on the next page.
My lords are fixing a date for the, my lords are fixing a date for the first hearing of the mediation, my lords.
That the mediation center will decide. The office will
Right,
take
my lord.
steps to refer to send the papers to the mediation center immediately.
My lords, only one clarification I want. I have no other means of livelihood except pension and the renting of that first floor, my lords. My difficulty is that first floor, to rent the premises in the first floor, my lords, there's objection, not by the appellant, my lords, appellant's husband. There are some protection can be given insofar as renting of the first floor is concerned. That's the only request.
Renting of the
First, my lord, second floor, they are staying, my lords, no difficulty. Ground floor, I am staying, no difficulty. First floor, my lords, I rent out the first floor. My lords, I've been renting it out from before, my lords. Only renting it out.
Your
Income,
father-in-law.
father, I have no other, I'm a retired police officer, my lord. Pension, apart from pension, I don't have anything else. Please accommodate me on renting.
Nobody is residing.
My lord, renting, my lords. I had rented it, my lords. He issued a notice to them, say, asking them to walk.
Parties are not residing.
Right now, nobody's.
The aforesaid order of the aforesaid interim order shall operate only in respect of the portions of the house where the parties are actually residing. If any floor is utilized for any other purpose, the interim order shall not operate.
Obliged. my lord. I think this should resolve the.
That's all.
Still number 19, complaints in contempt matter.
I appear for the complaint.
I appear for A1.
The respondent number 2 has to file the objections.
What is this?
My lord,
We have
in
filed
complaints of the order passed by the learned single judge, we have issued a circular requesting all the PSUs and boards to consider the
Representation.
employment of the
Considered.
petitioner. My lord, at page number 20, my lord, he was a employee under the PSU, STCL Limited, which is the subsidiary to STC, State Trading Corporation.
And subsequent to winding up of the company, all the employees sought VSS scheme. And they have received ex gratia also. Out of them, 10 were redeployed in some other PSUs and boards, my lord. The contention of on the requirement and suitability of the post. The contention of the petitioner that he was not redeployed. Because of the age restraint, he was not redeployed by the corporate board. And we repeatedly sent the circular to all the PSUs and boards to redeploy the petitioner, subject to the availability and suitability of the post. At page number 20, whatever maximum we can do, we have done, my lord. At page number 20 of my reply.
The contempt petition, you decide the representation.
My lord, this is pursuant to the order passed by this honorable court.
Of your reply.
Yes, my lord.
Where is that page 20? Page 20.
Page number 20 of my reply.
That is 6 September.
Yes, my lord, 6/7. The writ petition was disposed of on 27/2023. Pursuant to his application, we have sent this communication to all the PSUs, nearly some 29 PSUs and boards, my lord.
Where is the compliance that you show? Compliance to the direction, where is that?
This is the compliance, my lord. There was a direction to consider his representation. This is the maximum what we can consider, my lord. We cannot, under the central government, he cannot be redeployed. He was the employee of a company which wound up, PSU. At page number 22, there is a list of PSUs and boards. To all these PSUs and boards, we have communicated. Repeatedly, we are doing, my lord. During 2014 itself, he sought VSS.
Krishnamurti, Krishnamurti. This communication is made.
My lord, all the boards.
So you address the letter to some department.
All the PSUs and boards.
Then you get some response.
My lord, as per their rules and they have their set of rules and regulations.
One of them are coffee board, my lord, wide order dated 19/3/2024.
though I was not a party to the proceedings, I was made party to the present proceedings, my lord. And the letter what has been issued by the respondent number 1, we have received it and responded saying that he does not fulfill our eligibility criteria. Whoever fulfills our eligibility criteria, we have taken them on board. But we could not take him on board because he was above the age. The age limit was 40, he was 56, my lord.
Ages? What is the age?
Please, my lord.
Age?
Age criteria, my lord.
What is the age of the?
56.
56 at now, and when the application was filed, he was 46 years.
Okay.
And we have given I have produced it along with a memo for production of document as well as affidavit that we have sent response to the respondent number 1, informing that he does not fulfill.
You are appearing for whom?
Coffee board, my lord. By the order dated 19/3/2024, I was asked to get impleted, my lord, in the matter.
We'll consider on Tuesday. Wednesday, next Wednesday. You for it. Next Wednesday, come next Wednesday, 28.
Lords. The respondent number 2 has not filed their objection. I have not received a copy. They are just submitting it verbally.
Yes. What happened to 20?
This is regarding that permit, my lord,
My
bank
lord,
guarantee.
my learned senior had to file an affidavit along with a copy of the sale invoice.
Yes, that daily invoice.
As directed, I have filed the affidavit.
You filed?
I have filed, my lord, giving all the details with copies. My lord,
Including-
this interim order was in 2016,
Including the invoice amount.
including the sale price, my lord. My lord, what happens is sale price.
But I haven't got a copy. I'll look into it and make my submissions.
You don't have.
I
the
haven't received.
Then we'll put up on 30th.
Oblige me.
Learned senior advocate, Sir Rao, states that the affidavit as directed by the court in the previous order has been filed. However, the copy thereof is sought to learned additional government advocate Ms. Neelofer Akbar.
Copies are given.
Also in that view, in order to enable her to go through the affidavit, stand over to 30th of August.
Oblige me. Lord.
Very well. Next slide.
ಅಲ್ಲ ಲೆಕ್ಚರ್ ಬಂದಿಲ್ಲ ಅನ್ನೋ ಖುಷಿ ಬರೋದಿಲ್ಲ ಕ್ಲಾಸ್
ನೋಡಿ ಹೆಂಗಿದೆ ಕಂಟ್ರೋಲ್ ನಿಮಗೆ ಹಿಂಗೆ afternoon sitting will be there, but no matters will be taken. All matters will get there is dates. All matters will carry dates. Except till number 66 will be taken up. No. Date will be given afterwards. Only 66, item 66 will be taken at 2:30.
Court officer. Court officer. Court officer.
ಸರ್ ನೀವು ವಿಡಿಯೋ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ.
Court officer.
ನೀವು ವಿಡಿಯೋ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ಸರ್. ಯಾರು ಮಾತಾಡ್ತಿದ್ದೀರಿ?
ಮಾಡಿದೀನಲ್ಲ, ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿದೀನಿ.
ಬರ್ತಾ ಇಲ್ಲ. ಯಾರು? ಏನಾಗಬೇಕಾಗಿದೆ ಸರ್?
ಏನ್ ಸಾಹೇಬ್ರು ಇನ್ನ ಬರೋದ್ ಲೇಟಾ ಸರ್?
ಸರ್ ತುಂಬಾ ಜೋರಾಗಿ ಕೇಳಿಸುತ್ತೆ ನೀವು ಹೇಳೋದು.
ಹೌದಾ?
ಹಾ
ಅಲ್ಲ
ಸರ್
ಸಾಹೇಬ್ರು ಇನ್ನ ಲೇಟಾ
ಪ್ಲೀಸ್
ಬರೋದು?
ಎಲ್ಲರೂ ವೇಟ್ ಮಾಡ್ತಾ ಇದಾರೆ. ಪ್ಲೀಸ್ ವೇಟ್.
ಓಕೆ ಓಕೆ.
Chips kind leave. Can I make a mention of serial number 52, my lords? I appear for the complainant in serial number 52.1. Is connected with writ appeals. This is a case, my lords, where the complainants are the slum dwellers who were, my lords, rehabilitated way back in 1978 with an assurance that they will be given separate land and land will be acquired for road. From 78, we have been fighting for the cause. 2 contempts are over. Now BBMP had decided to give us the TDRs. Lords, that is now questioned, my lords, by the BDA rejects that proposal which is proposed by the BBMP because they don't have a land. Where we were rehabilitated and Hakupatras were given, BDA had acquired the land. Now we are left with in a lurch. The learned single judge has only directed TDRs to be given to us after looking into the entire records. We requesting, my lords. I represent the complainants in the contempt. Learned single judge's order. And that's the second or third round, my lords, of litigation. Only requesting some date, my lord, so that.
Where is the order under challenge?
In this, my lords, in the contempt, it's in volume 2, 397.
Same order, but where is it order?
That's the order dated 9th of March 2023. In the contempt, it's in volume 2 at page 397. Second volume. The relevant operative portion is at 469. We are about 136 slum dwellers.
What is TDR?
Well, it's transferable development rights because, my lords, what has happened is they don't have the land to give us. We were sent to one portion of land which was already acquired by.
This was once heard, man.
Long back. That's why.
Long back.
For some date, my lord, because we are now without any. All these people are accommodated in rented places with in slums. In fact, in the earlier contempt proceedings, BBMP had given an assurance they'll give whatever clarifications required by BDA. BDA is only an issuing authority, but they reject our claim. 1976, we were shifted out for formation of road.
So we'll take up the appeal itself.
They have also filed, what has happened against the learned single judge's order, they have filed writ appeals. BBMP, which had conceded to the fact they'll issue, even they have filed a writ appeal. Oh, my lords, everything is clubbed and now we are in,
We'll take up on 13th.
13th, please.
13th.
I request 2:30 if possible. my lord.
We'll take up,
Please,
please, remind us.
please.
Send out to 13th September. You for reading. Interim order granted earlier in the writ appeal number 440 of 2023 shall continue to operate till the next date.
Serial number 84. Vacancy. Can listed any day next week.
84.
84, last night.
Right. What is it about?
Say next week, if you any day.
No, what is the subject matter?
Not the subject is this, my lord. Petitioner. Yeah.
But why you-
Appellant is the wife of the first respondent who borrowed loan from the bank. Subsequently, of which I am half owner of the property. Subsequently, what has happened is I have undertaken to repay the entire loan which the husband has taken. There are divorce proceedings pending. There, but still I ventured to repay the loan. The only request, the prayer I made, I filed an affidavit before the learned single judge and said that I will repay the entire loan. Undertaking is also filed, affidavit is also filed. Only thing which I said was, on my payment of the loan, the documents and discharge deed will be granted in my favor because I am half owner of the property. That has not been called out in the order. Therefore, the bank is refusing to release the documents in my favor, though I have undertaken to repay the entire amount.
So respondent 2 is entitled to secure possession of property,
But I am in possession of the property.
which is that residential house. Residential house.
Yes, it's a residential house, of where I am staying with my two daughters.
All that will take up. So you have agreed to pay as per the order.
I have undertaken to repay. Only thing is the documents and discharge can be made in my. That affidavit also I have filed, but unfortunately, the learned single judge has not culled out that part of the order. Therefore, the bank is saying now you only pay the money.
They are agreeable to, other side is agreeable?
If the other side is agreeable, we can proceed.
Let us. When shall we keep, tell the date?
Any date, my lord.
If
Your lordship.
this is the only point we can take up. This is the only compass of the matter.
This is the only.
3rd September.
Please.
My
3rd
lord,
September, 2:30.
my lord, I had one memo for posting.
Mr. Counsel, this notice is to be issued? Notice is not issued?
Notice is not.
Then we'll issue notice returnable.
Emergent notice.
Notice returnable, then little longer. 11th.
Please.
Office of Justice shall be removed before the next.
I'll look into that. My lord, I'm appearing for petitioner appellant. My lord, in this matter, I wanted to file one memo for posting.
Pardon?
I'm filing for memo for posting.
Posting, you can't mention.
My
it.
lord, so I supposed to file today morning. Matter is very urgent, so that's why I'm requesting to file
Mention
today.
in the morning. What is
Matter
the
is
urgency?
very urgent, my lord, that's why. My lord, in this property, appellant are staying in the government property.
No, you can't mention. For memo, all can't be mentioned at 2:30.
Matter is very.
Only at 11. Mention tomorrow. No.
My lord, matter is very urgent, my lord. That's why property,
Then tomorrow.
house property and they destroyed my Tahsildar.
Pardon?
So properties, house properties and destroyed by the Tahsildar.
Destroyed.
Yes, my lord.
Mention
That's why.
tomorrow.
That's why I'll comply the office objection. Kindly permit you to comply the office objection so that.
2:30 will not entertain any memo.
My lord, sorry
Mention
for,
at
sorry for a small request, my lord. Very urgent matter, so that's why I will comply office objection. Kindly raised.
Why they are demolishing? Why the Tehsildar is demolishing the property?
Sir, my lord, that property belongs to government. Government has purchased the property under the Asraya scheme for who have not site and homeless. For that, Gram Panch.
It's appeal, writ petition, PIL. what
Yes,
is
sir,
it?
impugned order passed by this honorable High Court. So,
Writ appeal.
writ appeal number 23 bar 23/074 of 23.
So what is the order passed by learned single judge?
There also dismissed the appeals, so that's why.
Tomorrow, 2:30.
Much.
Serial number 66.
Lords kindly, serial number 65. But rejoined affidavit is ready. May I request, my lord, first week of September, my lord, I'll file it in the registry.
Second.
Matter was listed, my lord, on 19th. I filed compliance affidavit indicating, my lord, that I have complied with the single judge's order, my lord. Of course, with a little bit of delay, which I've tried to explain. The affidavit.
So when do you want to list?
Lord, it was listed today, my lord, for 2:30 because I filed a compliance.
Second, he is seeking time, 2nd September.
Please.
Right.
Number 66.
I appear for the state.
Lords, yesterday's matter.
Or learned, yes.
Lords, the submission, Lords, was made that, Lords, there is no material placed on record to show that, Lord, I represented the country, Lords, things. Lords, I have prepared, Lords, a rejoinder submissions. And, Lords, I got hold of, Lords, from the website of the All India Chess Federation itself. Lords, if I'm permitted, Lords, the submission, Lords, I've served copies on the other side. Your Lordship, my Lords, I have produced, Lord, 2 documents along with the decisions of this Honorable Court and the Honorable Supreme Court. The document, my Lord, clearly shows that it is the Indian contingent which was sent to the event. And my name is there, my Lords, as a member of the contingent. Not that clearly establishes, my Lords, subject, my Lords, anyway, my Lords, I have made some legal submissions, my Lords, about FIDE and my Lords, how the teams are.
Respond to that.
My Lords may have a look at, my Lords. May have a look at, my Lords, the doc.
You're filing something.
Yes, my Lords. I am
Copies.
filing. I have served a copy, my Lords. Rejoined, my Lords, to.
Any of you want to respond to this or?
My lord, I have to respond to this. They have served it at 2:30. All I want to do is, my lord,
Tomorrow, then Monday, Tuesday.
I leave it to my lords.
Instead, my Lords. Instead, can it taken on Wednesday, my Lords?
Wednesday.
Please.
Learned advocate, Mr. So and so and so. Files. Rejoinder, what is that? Files, what is that memo?
Lords, rejoin the submissions, my Lords, to, my Lord, what the submissions which are made yesterday. My Lords, I have prepared, my Lords,
Rejoinder
the submissions.
on behalf of the petitioner, which is taken on the record. Also filed is the, you are also filed,
No, this is last yesterday.
also filed.
Give it to the chat.
That is not necessary.
Yes.
That's only four, my lord.
Also filed is the memo. Also filed is the memo dated memo dated 21/8/24. My learned advocate for respondent number 1. Detailing giving the details of certificates of the petition. Certificate petition.
I'll just correct the date.
As requested by counsels for the parties, stand over to 29th.
Yes, Wednesday. Please.
May I seek my lordship's indulgence, my lord? I've also prepared one chart, my lord. My lord said directed me to.
And for reading of this law.
I'll file it along with the memo. my lord.
Light. You.
That we have detailed the number of tournaments that they've entered. And what is the reason for them to be eligible and not eligible? The reasons are also assigned on the right-hand side.
Why not eligible?
My lord, insofar as the first one is concerned, she's participated and she is eligible. my lord.
Yes.
Insofar as the second, third, and fourth are concerned, because they don't satisfy the cutoff date. They don't satisfy the cutoff date criteria, my lord.
Cutoff.
That is the only reason, my lord. And the fourth one, fifth one, my lord, is it's an invitation tournament and hence it's not considered. And the sixth one will not make them eligible. They have not won any medal. Copy.
Permitted to correct the date, my lord. Sorry. Date in the memo, I'll correct it. No problem.
Please.
Read.
Court officer. Court officer. Court officer. Jaffer correct ಮಾಡಿ. Jaffer. ಎದ್ಬಿಟ್ಟಲ್ಲ 66ಗೆ. ಎಷ್ಟಿಗೆ ಎದ್ರು?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅಥವಾ ಬೆಂಚ್ ಕ್ಲರ್ಕ್ ಯಾರಾದ್ರೂ ಇದ್ದೀರಾ ಸರ್ ಆನ್ಲೈನ್?
Court officer, sir. Sir.